Respondent in the appeal, Scott of Southern Pacific Mortgages Limited.
Lady Hale will explain the judgment of the court.
This is a test case arising from sale and rent-back transactions in the northeast of England. For the purpose of the legal issues arising, the assumed facts were these. Homeowners, like the appellant, who was having difficulty keeping up the mortgage payments on the home which she had bought from the council under the Right to Buy scheme, were persuaded to sell their homes on the faith of promises that they would be able to remain in those homes indefinitely as tenants after the sale, and even pass them on to their relatives. Unbeknownst to the sellers, however, the buyers borrowed money on mortgages from lenders who did not know of the promises which had been made to the sellers. Indeed, the terms of those mortgages prohibited the buyers from granting long-term tenancies to anyone. The buyers, having had the benefit of the money lent, then defaulted on their mortgage interest payments. The lenders therefore brought proceedings to recover possession of the properties. Only then did the sellers find out what had been going on. The issue in the appeal is whether the sellers have any proprietary rights which would entitle them to remain in their homes as against the lenders, as opposed to any personal claims which they might have against the buyers or their solicitors. Under the Land Registration Act 2002, the rights of a buyer or mortgagee are subject to what are known as overriding interests. These include the interest of a person in actual occupation of the property. So the question is whether, when the contract of sale was made, the buyers were able to confer a proprietary right upon the sellers, which would be binding on the lenders. This would have to happen at the time of the contract, or at least before the sale was completed, because it was held by the House of Lords in the case of Abbey National Building Society against Cannes, that where a buyer buys property with the help of a loan secured by a mortgage, the buyer's rights, and therefore any rights deriving from the buyer, are subject to the rights of the lender under the mortgage. The Supreme Court unanimously holds that a buyer who has contracted to buy land does not have a sufficient interest in the property to be able to confer a proprietary right on anyone else until the sale is completed. And whereas here, completion of the purchase and the buyer's mortgage are simultaneous, it is too late. The rights of anyone to whom the buyer has made promises before completion are subject to the rights of the lender under the mortgage. The result is that the sellers have no right to stay in their homes. As between the sellers and the lenders, both of whom may well have been defrauded by the buyers, this all-or-nothing approach seems harsh. The Law Commission's wide-ranging review of the Land Registration Act, which will include the impact of fraud, is to be welcomed.